Good morning, everyone. I'm Bridget Polachine, CEO of the IIB, and I'd like to welcome you to today's webinar to explore the New York Whistleblower Law that took effect in January of this year and what IIB members can do to avoid and defend against any liability. Leading today's discussion is a great friend of the IIB, Philip Berkowitz, co-chair of the financial services practice at Littler, and his colleague, Jeanine Conley Davis. Phil and Jeanine are both highly skilled and experienced employment lawyers, having represented large domestic and international companies and aiding companies in employment-related disputes and workplace investigations. They're happy to take questions throughout, so please take advantage of having these experts here with us today to learn more about this important law and the potential traps in complying with it. So with that, Phil, and just reminder, I'm sure everybody has this down by now, but you can submit the questions via the Q&A function at the bottom of your screen or via the chat. So with that, Phil, I'd like to turn it over to you.
Thank you. Thank you, Bridget. Thank you, IIB. Thank you, everybody, for signing in today. So we are going to actually be we're going to have assistance from Adrian at IIB in moving our slides forward. So we're going to be asking her to move forward, which I will do at the moment. And there we are. Look at us. We look fabulous. We're very happy to be here. Adrian, you can move us forward again, please. And our agenda, we have too many topics to list. We ran out of space. So we started to list them, but let's just get to the actual substance of what we're talking about today. Thank you. So everyone, we are seeing a huge increase in whistleblower claims and whistleblower awareness on the part of employers and employees. This is due, I think, in some measure to legal developments. There have been a number of legal changes. We're going to highlight the new whistleblower law in New York in a few minutes. There's also been a strengthening of other whistleblower laws that affect banks. The Bank Secrecy Act was amended recently. We're going to talk about that. But it's not only due to legal developments. We think that perhaps more important, this increase in whistleblower claims, in claims of employees who think they're being retaliated against for blowing the whistle on improper conduct, is attributable to what we've all gone through during the past couple of years. This COVID, working remotely, the uncertainty around the whole situation. We're going to come back to work. We're going to reopen. We're going to have hybrid workplaces. You're going to work 2 days a week. You're going to work 3 days a week. No, you're not. You're going to go home. We're not going to, everybody comes in, everybody catches COVID. And so there was that was a great idea, but now we're back and trying to figure out what we're going to do next. The anxiety around travel, the opposition to vaccines, the efforts by employees to avoid vaccinations because of religious belief or because of a disability, the lack of personal contact with colleagues, and it works both ways, whether you're a boss, whether you're a manager, or whether you're somebody who's being managed. People are just anxious. What about their kids? What about their families? Email being the primary manner of supervision and communication. So what we're seeing, I think, is a lot of anxiety in the workplace. People maybe, you hear about the great resignation or the great reshuffling, whatever it might be. Sure, there are a lot of people who are taking advantage of the situation and finding other opportunities, but there are also people who are worried about their jobs and worried about how they're being judged. And so we are we're facing, I think, we are seeing an increase in legal claims. So what is whistleblowing? Whistleblowing is easy enough. Whenever, to define, whenever somebody makes a claim that the employer has engaged in improper conduct of some nature, they are technically a whistleblower. If the Occupational Safety and Health Administration receives a claim from an employee that there are unsafe conditions at the workplace, that person is a whistleblower. So reporting information or concerns by individuals that they reasonably believe constitutes illegal conduct, unethical conduct, which may or may not be conduct that affects the safety or soundness or reputation of the institution. This is whistleblowing. And a whistleblower, depending on the statute, may be defined narrowly, just as an employee, or it could be a former employee, it could be an agent, it could be a consultant, it could even be outside counsel. So there are many people to whom the label of whistleblower may attach. Next slide, please, Adrian. So, okay, we know now what a whistleblower is. And once you blow the whistle, there are many laws that provide protection to the whistleblower against retaliation, that prohibit retaliation against the whistleblower for blowing the whistle. And this, of course, is what we mean by a whistleblower case, a whistleblower retaliation case. And what does a whistleblower retaliation case look like? The whistleblower engaged in protected activity. They became a whistleblower by complaining about conduct that they reasonably believed constituted a violation of some sort. There may be, and we'll talk about this maybe a little bit more later, but how do you determine whether someone had a good faith belief? Subjectively, might they, could they say that because of their knowledge of the industry, they knew that there was a problem? And objectively, would somebody looking at the situation just normally agree that there was some kind of bad conduct that they were blowing the whistle on? So the elements: the individual engaged in protected activity, the employer who's accused of retaliation knew of the protected activity, the whistleblower suffers some kind of adverse action, which is normally going to be employment-related action, but we'll see when we talk about New York, could be even some other kind of action, that there's reasonable cause to believe that their whistleblower activity contributed to the adverse action, that there's what we call temporal proximity, that the whistleblower activity, making the complaint, and the adverse action occurred reasonably soon after making the complaint. So if somebody was mistreated a year after making a complaint, it's less likely that there's retaliation, that there's going to be, that a court would consider that retaliation occurred. And finally, did the decision maker, the person who carried out the adverse action, know about the complaint? Normally, you would need to demonstrate that the person who had a role in the adverse decision knew about the bad conduct. Otherwise, it would be difficult to demonstrate that there was retaliation. Next slide, please. So a couple of reasons, and we're going to emphasize this too, why whistleblower claims are difficult and a problem. The individual doesn't need to be correct that bad conduct occurred. The individual could be wrong or mistaken that there was a violation of law or some kind of ethical problem. As long as they had a reasonable basis for believing that it occurred, they're going to be protected against retaliation. And human nature is such that it is easy to believe that if someone is accused of wrongdoing, of misconduct, of a violation of law, that maybe they would have taken some kind of adverse action against the employee. So just human nature is such that a jury who could very well hear one of these claims would say, you know what, if I was accused of something like that, I don't know how I'd act. And it's easy to believe, looking at that person there, that they, in fact, made that negative decision because of the complaint that was directed to their conduct or to some conduct that for which they were responsible in the organization. Next slide. So what kinds of, next slide, please, Adrian, thank you. There are all sorts of bad things that an employee could claim that they experienced because they reported misconduct. This ostracizing thing at the very top is is often alleged that they were ostracized by their colleagues or they were ostracized by people they otherwise worked with. And of course, being excluded from various opportunities, having their responsibilities changed, somebody saying bad things about them, and so forth. And so being demoted or not getting a promotion, relatively low on the list. It's more like suddenly I'm an outsider. You know, I complained and suddenly I'm not being included in opportunities. My duties are being reassigned. And I can see that my future here is not what I had hoped and expected it would be. That's the claim. Next slide, please. And, you know, these cases can result in very significant claims of damages. This is just one example of a recent case involving Wells Fargo, where there was a Sarbanes-Oxley claim. And we'll talk about Sarbanes-Oxley in a moment, but Sarbanes-Oxley whistleblower claim, where this manager was dismissed after he reported what he believed to be wire, bank, and mail fraud, and OSHA awarded all of this money. Again, these claims are, retaliation claims are easier to prove than claims of underlying inappropriate conduct. You don't have to prove that the conduct occurred. You don't have to prove that the bad conduct occurred. All you have to prove is that you had a reasonable basis for believing that it occurred, and then that somebody didn't like the fact that you were complaining. And again, human nature being what it is, it's not so difficult to believe that it might occur. Next slide, please. Banks. We're here because we're banks, right? And banks are particularly vulnerable to cases like this, not because that they do bad things, but because they are so heavily regulated. Banks are subject to, you know, anti-money laundering, anti-terrorist financing. You've got regulators sitting down the hall, you know, you've got so many individuals who are responsible for looking to make sure that we're doing the right thing, who are working in compliance functions. They may be employees, they may be consultants, third-party vendors, and their job is to see whether, you know, the bank is complying with these various laws to which they are subject. And the regulator, as I said, is easy to reach by email, or they might be in residence, when you're remediating in a consent decree or consent order. And of course, regulators, as you know, can even more than juries, perhaps, are more of a concern to banks than, in some cases, than the risk of litigation, because the regulators can really put you out of business, or they can impose extraordinary fines. And a couple of examples here that date back a few years to, you know, issues of AML, allegedly deficient AML practices, as well as this FCPA case involving hiring of individuals who, for the purpose of trying to get business from government officials. So banks are significant targets. Next page, please. And next page, please. Thank you. So what is protected activity? As we already said, it could be anything. It could be a claim under the discrimination laws, or it could be under whistleblower laws. And usually it involves a communication about the issues that we're seeing here, as well as things like failure to comply with AML laws and similar issues for banks. So all of these kinds of claims can result in whistleblower claims and claims of retaliation. Next slide, please. I just want to spend a moment talking about a couple of statutes that we need to be concerned about. Before I talk about the Bank Secrecy Act, I mentioned before Sarbanes-Oxley. Sarbanes-Oxley was kind of the original federal anti-whistleblower law that applies to publicly traded companies, and it was passed in the wake of the financial crisis, and in 2008. It provides for a very significant whistleblower remedies for individuals who complain about conduct that may constitute fraud against shareholders, and it is directed to publicly traded companies. It also introduced this notion of bounties for employees who could get between 10 and 30% of any amount recovered by the government in a prosecution. We had Dodd-Frank, which amended the Sarbanes-Oxley Act and provided protection for certain employees of some financial services companies, principally involving consumer loans and similar activities. And then, of course, we had the Bank Secrecy Act, which was just amended actually in December 2020, which also adopted this notion of bounties for people who complained about anti-money laundering activities and who claimed that they were retaliated against as a result. Interestingly, the Anti-Money Laundering Act does not include Sarbanes-Oxley's minimum 10% award. It says that you're going to get up to 30%, but there is no minimum. And so many plaintiffs' lawyers are upset about that because they say they could get a $1 award. But the employer can avoid liability under these statutes generally if they can establish, as we note here in the bottom bullet, that by clear and convincing evidence that we would have taken the same action against the complainant even if they had not complained, which of course, you're sort of proving a negative there. How do you show you would have done the same thing even if the person had not done something that they actually did? But anyway, let's move along to the New York Whistleblower Law and my dear friend and colleague, Jeanine.
Thank you, Phil. So the New York Labor Law, Section 740, is the Whistleblower Act in New York, and it has been significantly expanded. It went into effect January 26, 2022, these new amendments, and it effectively brings New York in line with many states that already had very broad whistleblower laws, like Massachusetts. You have the Conscientious Employee Protection Act in New Jersey, and certainly California, which is always pretty expansive, but New York is right along those lines now. It, in terms of who it protects, it eliminates application to just employees. Now, former employees are also protected to ensure that former employees can't be retaliated against even after they have left the employer. And it also includes independent contractors, which that used to be a complete defense. If someone was an independent contractor, it brings them into the fold of the New York Whistleblower Law as well. Now, under the prior law, an individual would be protected for disclosing to their supervisor or public agency a violation that presented a substantial or specific danger to public health or safety. And that was amended in 2002 to add healthcare fraud. But you can see that's very narrow, public health or safety or healthcare fraud. Now, that with the amendments, that it prohibits, the new law prohibits retaliation for disclosing or threatening to disclose to a supervisor or public agency any conduct that they reasonably believe violates any law, rule, or regulation, executive order, or any judicial or administrative decision, ruling, or order. And it also includes what it did previously, that they reasonably believe constitutes a substantial and specific danger to public health or safety. But you can see extraordinarily broad in terms of the amendments that added basically any law. Next slide, Adrian. So what constitutes retaliation? It's what we typically think about, right? Adverse employment action, discharge, suspension, or demotion. But it also includes reporting or threatening to report an employee's suspected citizenship or immigration status, or the suspected citizenship or immigration status of an employee's family or household member to a federal, state, or local agency. So that's very different from language that we've heard in prior whistleblower statutes. It adds this immigration element to it as well. And not only the discharge, suspension, or demotion, but threatening to discharge, suspend, or demote also included in these amendments. Remedies, you have a civil action for injunctive relief, but it adds reinstatement for front pay in lieu of reinstatement, reinstatement of full fringe benefits, seniority rights, lost wages, benefits, other remuneration, cost disbursements, and attorney's fees. Again, broadening. These used to be bench trials. It even broadens that to give individuals the opportunity for a jury trial. Now, what we don't see is that employers still appear to be able to have their employees sign arbitration agreements, which would effectively waive the jury. The statute, the amendments did not take that away, but the employee is certainly entitled to a jury trial if they want one. And the employer may defend by demonstrating that the alleged retaliatory action was in fact predicated on grounds other than the employee's exercise of their rights under the statute. And Phil talked about that a little bit. We'll talk about that a little more. Next slide, Adrian. What is a supervisor? Even this definition is quite broad. Even in Massachusetts, you see that a supervisor is defined as someone that the employer designates to have direct authority and can actually give corrective action. Here, it's who has the authority to direct and control the work performance of the affected employee, or who has managerial authority to take corrective action regarding the violation of the law, rule, or regulation of which the employee complains, at least under the Conscientious Employee Protection Act in New Jersey. That who has the authority to direct may not be someone actually designated by the employer to direct, but someone who in the normal day-to-day directs that employee. So a very broad definition. Next slide, Adrian. Interestingly, for public body, for that definition, they expanded that as well. You can see here the list of all the public agencies and everything that it entails. And then they made sure to add as well any federal, state, or local department of an executive branch of the government. And for good measure, any division, board, bureau, office, committee, or commission of any of the above public bodies. So it's covering everything. They didn't forget anybody in the definition of public body. Next slide. Another really big thing in this expansion with the amendments is that you don't have to show an actual violation of law, which you used to have to do under the original law. Now it's only a reasonable belief that a law was violated. Again, that language in the statute, any conduct that they believe is a violation of any law, rule, or regulation. So how do you determine if the employee has a reasonable belief? How do you measure this? Obviously, we don't have a lot of case law yet with the amendments just made January 26th and going into effect January 26th, 2022. But as Phil discussed, we expect to see a ramp up of activity with the use of this new expanded law. We think that reasonable belief you're going to still be able to use as a defense, as we have used in prior cases and with other whistleblower statutes like SOX, that there was no reasonable belief because there's an objective element under the standard. And we think that will likely continue with this expansion of the New York Whistleblower Law, in that it looks to the person's actual training and experience. So would a person with that actual training and experience have reasonably believed a law to have been violated? And many cases show that that has been a defense that employers have been able to use, where the person, for whatever reason, they're the principal accounting officer. If they think that the company's cooking the books, then yes, maybe a person with that training experience does have a reasonable belief that there's a violation, but in other contexts, maybe not. So you're looking not only at the subjective, but also at the objective view of that person. Next slide. So we talked about this a little bit. Pre-January 2022, the whistleblower had to first bring unlawful activity to the attention of the employer, and then they have to give that employer a reasonable opportunity to cure. Now the whistleblower need only have made a good faith effort to notify his or her employer. And you can see that there are several exceptions for when they don't necessarily have to bring it to the employer. If there's imminent serious danger to public health or safety, okay, that makes sense. Such activity, policy, or practice could reasonably be expected to endanger the welfare of a minor. Also clear, but then there are several others that are more broad. The employee reasonably believes that reporting to the supervisor will result in destruction of evidence or other concealment of the activity, policy, or practice. The employee reasonably believes that the supervisor is already aware of the activity, policy, or practice and will not correct such activity, policy, or practice. Again, those are sounding a little bit more subjective, so it sounds like the exceptions could basically drive the proverbial truck, through this opportunity to cure, which has been changed to the good faith effort under the amendments. Next slide. And so where does that leave us? We have a significant erosion of the employment at will doctrine, which is where we started in New York. And we've seen lots of laws in New York that have slowly eroded that doctrine in New York. We expect a significant increase in litigation and legal risk. Again, it was effective January 26, 2022. And we expect to see definitely a ramp up of litigation here. And then you need to revisit policies and training protocols. It's key that managers know how to respond to complaints, and that policies must encourage employees to disclose concerns to managers, human resources. We'll talk about that a little bit more at the end as well. I'll turn it back over to Phil.
Thanks, Jeanine. Can Adrian please move forward? So what do these policies look like that Jeanine talks about? Why do we create these policies anyway? I mean, to get ourselves in trouble? I mean, why encourage these rabble rousers to come forward, right? Why encourage employees to bring claims? Why do we want to put a policy out there that says if you think there's something bad, you got to please tell us about it? Well, I mean, I hope obviously it's in our interest as employers to do this. And by the way, many of the laws and regulations and regulators require this. If you're regulated by DFS, for example, you know that they have a whistleblower guideline on whistleblower policies that are very detailed. And so why do we do this? It's in our interest to do so, in addition to having laws that require it, so that we can discover wrongdoing and take action to prevent the wrongdoing. And indeed, courts have said that we might even be able to avoid liability entirely if we have a policy in place and employees fail to avail themselves of the policy, or if we take action to promptly remedy the problems. So we encourage employees to raise these concerns. We should partner with various, every entity is going to have their own internal procedures to ensure that the concern is properly reviewed. But the manager is a key player in being sure that the whistleblower is heard and that the issues are dealt with without retaliation. Adrian, next slide, please. So under recommended policies, and certainly as the DFS recommends, the whistleblower has the right to make a claim anonymously, and their identity and should normally remain confidential to the extent that it can be, to permit the employer to conduct, the bank to conduct a thorough investigation and to help it comply with the law. But there are cases that have said, for example, there was one case where at a board meeting, a member of the board said, oh, I think I know who the whistleblower is, it's this person. And just disclosing it internally, the identity of the whistleblower to other members of the board, the OSHA, which hears Sarbanes-Oxley whistleblower claims, determined that that disclosure constituted unlawful retaliation. So we have to be very careful about disclosing the identity of whistleblowers to anybody, including, of course, the individual who's accused of wrongdoing. Again, this the need to keep to anonymize folks and to protect the confidentiality of the investigation has to be weighed against, on the other hand, the need to conduct a thorough and fair investigation, because sometimes you're just going to have to reveal certain information in order to get details, in order to know whether bad conduct occurred. Next slide, please. Of course, any policy is going to need to make clear that retaliation is unlawful. There are a number of issues that we will speak a little bit more about in a couple of minutes, but that we need to be sure that when there's a claim brought, that the investigation is fair from a number of standpoints, including the lack of conflicts of interest, and the employee needs to have confidence that their claim will be fairly investigated, or at least we need to be able to demonstrate that we showed that the employee should have confidence in the fairness. You can't guarantee that every whistleblower is going to feel that way. I have a matter now where an individual evidently feels that their claim may not have been handled appropriately, but nevertheless, we feel that we can demonstrate that it was. You can't satisfy everybody. You need to, though, have internal policies in place that do, in fact, investigate claims that appear to have grounds and to conduct a fair and full investigation. And of course, the policy needs to prohibit retaliation, and individuals who do engage in retaliation, in inappropriate retaliation, should be subject to discipline, which may include termination of employment. Next slide, please. So what are other essential pillars of a whistleblower policy? That we clearly publicize the right to bring these claims, that individuals know that they can bring these claims safely, that we're going to properly investigate, that we're going to take appropriate remedial action where necessary. And by the way, not on this slide, but what also needs to be very clear and set forth in a whistleblower policy is that individuals who bring these claims have a duty to cooperate. And indeed, anybody who is the subject of an investigation internally has a duty to cooperate, and that individuals must not bring claims if they have no reasonable basis for it, and that the company or the bank will not tolerate, reserves the right to discipline individuals who bring claims in bad faith, who bring claims without a reasonable basis for believing that the claims are true. So these policies should also preserve the employer's right to discipline in the event a claim is not brought in good faith. Next slide, please. and move forward? Thank you. So a couple of things that are peculiar, if I may use that word, to the banking industry, we need to mention, and that is there are special rules. And, as counsel, if I'm called and, I may get a call from a bank client who says, we've got a whistleblower claim. We have an issue where somebody is claiming that they were retaliated against because they went to a regulator and they complained about improper conduct. Okay, and their boss knows that they sent this email to the regulator, or they gave a report to the regulator, and we want to see, and so the claim is that the individual was retaliated against. And as counsel, I might say, look, I'd like to see those documents. I need to see what was submitted to the regulator. I'd like to see the regulator's response. Or we might even have a case where opposing counsel wants to see those records, right? The employees' counsel says, I want to see those records that were produced. And there might even be third parties, like other agencies, who say, I want to see bank documentation to determine whether there was discrimination. And there are other circumstances in which you might have good reason for wanting to see internal documents. You might be conducting an investigation of the claim. You might even retain a third party to conduct an investigation. Well, that should be fairly straightforward, right? I want to see those documents. I'm the bank's lawyer. Please hand them over. But as we know, next slide, please, Adrian, it's not so simple when we're dealing with banks, because banks are subject to regulations that restrict sharing of information, sharing of what's called CSI, confidential supervisory information, which may differ, and in fact, which does differ depending on the regulator you're dealing with, but generally involves these kinds of examination materials, information that the agency gathers in the exercise of its enforcement responsibilities, and information that we prepare for the regulator. And there is, in fact, a definition in the New York banking law of CSI, which says that this information shall be confidential and is not subject to subpoena and shall not be made public unless, in the judgment of the DFS superintendent, the ends of justice and the public advantage will be subserved by its publication. So there are restrictions, statutory restrictions, on disclosing this information. And next slide, please. Even to counsel, okay? So the FDIC says you need their prior approval before you disclose CSI to counsel. And the different regulators have different views. The Fed, the OCC, the CFPB say, well, it's okay to disclose it to legal counsel without our approval if it's necessary or appropriate in connection with providing legal services. And also this applies to your external auditors, very similar restrictions and similar permissions. And counsel, if in the eyes of the Fed and the OCC and the CFPB, can share that information with third parties we might retain to assist us in providing legal advice. If it's necessary to do so, we have to have a written agreement with the institution agreeing to keep the CSI confidential. And by the way, the Fed recently revised their regulations to actually permit counsel to review CSI off premises of the financial institution. It used to be that you actually had to go to your client and look at the damn documents in their office. Next slide, please, Adrian. DFS, excuse me, DFS takes a slightly different view. So first of all, you have to, the rule in general is that you have to get prior written approval to disclose any CSI, but it's okay to disclose it to affiliates and directors, officers and employees when necessary and appropriate for business purposes. And it's okay to disclose to your lawyers if they are retained and engaged pursuant to an engagement letter, which includes acknowledgments that the information will be used only to provide legal representation. There is no exception for third-party vendors. So if I want to retain a third party to help me it appears that I need to seek, or the institution must seek, DFS's written approval to do so. And so the DFS and also wants to be immediately notified if there's any request or subpoena or court order to provide CSI. So this is a complication in representing banks that your counsel and you need to be aware of. And of course, finally, next slide, please. We have this extraordinary SAR privilege, which very few lawyers know about unless they're dealing with the financial institution regularly. But the notion that these SARs are in fact legally, they are confidential as a matter of law, and indeed there can be a criminal violation in disclosing the fact that a SAR was filed, disclosing it to the individual who's a subject of the SAR. So there are numerous laws and regulations that restrict the disclosure of information that may be important to your counsel in investigating a whistleblower claim and in helping the employer, the bank, defend the whistleblower claim, that you need to be aware of as a financial services institution when we're talking about whistleblower claims. Back to Jeanine.
Thanks,
Adrian.
yeah. So let's talk a little bit about responding to complaints and how we respond to complaints. And I will say we're at about the 15-minute mark, so you should feel free to put any questions in chat and we can answer those throughout if you have any. But as you're preparing, for the complaints, the supervisor's role is very important. First, you should know that more than half of all complaints go to supervisors. So more than half are going to supervisors. So how the supervisor is responding to those complaints is really key. And the supervisor has to help really set that tone from the top and vigorously enforce policies and the code. And to do that, of course, to vigorously enforce them, you have to make sure that you understand the code and you actually understand how it applies and be open to answering any questions. You also need to create that open environment where people feel comfortable coming forward with their complaints and really create this atmosphere of compliance. Next slide, Adrian. When Phil started talking about the policies, he mentioned, why do we even have these policies in place? And as he discussed, and as I've seen with a lot of my clients, those who have the policies in place, those who really are welcoming the complaints and the reports, are having an opportunity to address these types of complaints. Supervisors need to, take that time to listen, really do active listening, and being professional and respectful at all times when you're dealing with someone, even if that person is, a repeat complainer. I've seen situations where, there is a repeat complainer, certain things have not been substantiated, but then that ultimate complaint, was substantiated. So take all complaints into account and take them seriously, and listen and partner ASAP. You've got to, and I had this recently where someone did pick up on certain statements that were made and partnered with legal compliance. And this was an HR individual to make sure that everyone was involved, and so that we could resolve matters quickly. Next slide, Adrian. What not to do. Several things not to do. We've already talked about, not to retaliate. But very important is also not gossiping, talking to others, and making sure that you're not sharing more broadly than with those that need to know. And I recently saw that being an issue where an employer had sort of extended out to too many people. Too many people had concerns about where this stands, where this is, So you want to keep that, the need to know crowd very narrow, and make sure you're not making jokes or trivializing the issue. Next slide, Adrian. Also thinking about some distinct tasks. You need to, at that stage, you've received the complaint, you need to start considering whether the claim is brought in good faith. Did the whistleblower have a reasonable basis for believing that wrongful conduct occurred? You want to start determining whether, in fact, wrongdoing has occurred, whether a self-report to regulators makes sense. And there are cases where it makes sense, particularly where you think that whistleblower has given you every belief that they are going down that route. Sometimes the company coming to the regulator first makes the most sense in getting in front of that. You want to guard against retaliation against the whistleblower. Very, very important that you tell those key people that are involved that they should not be retaliating against that individual, and Phil listed off all the different things that the person can do to retaliate. One that I keep seeing most commonly is that you just keep them out of meetings or don't meet with them. You can't go down that route either, because that can be seen as retaliation. And make sure to protect the confidentiality of the whistleblower to the extent possible. Next slide. Back to you, Phil.
Okay, and so what are we seeing? I mean, we're actually seeing, excuse me, banks responding pretty vigorously. Not only banks, but many international companies. But certainly, we're seeing a lot of our bank clients, international bank clients, and otherwise, really responding with vigor to these issues. And the first is they are revisiting their whistleblower policies, and we've listed here. The DFS in 2019 issued this guidance, which I'm sure many of you are familiar with, these 10 pillars of an effective whistleblower program. This is kind of consistent with what we've already talked about, but these are the things that DFS is looking for, and frankly, should be a part of any effective whistleblower program. And what are they also, so, I mean, we see what they are: publicizing, well publicized, protection for anonymity, being sure that where investigations are managing conflicts of interest, we have training, that we're investigating appropriately, that we're following up, that we're protecting retaliation, confidentiality, that there is oversight by key individuals, and that we have a top-down culture. The other thing that these regulators are looking for is that you're publicizing these. And when I talk about well-publicized, they want to see them on your website. I mean, they want to see this being pushed out, not only internally, but externally. And again, in New York, these laws protect consultants, they protect former employees. So you need to think about not only an internal policy, but do you want to put something out there on your website as well? Next slide, please. What we're also seeing in response to this is employers putting in place internal protocols for investigations and escalation of claims. These are taking the guidance in terms of what DFS says in terms of being sure that you have a proper investigation policy and putting them in black and white. So everything from the initial triage of a claim, who's going to investigate, being sure there's no conflict depending on who's responsible for investigating, dealing with privilege. Do you want counsel to investigate, whether internal or external, to try to preserve the privilege of the investigation, and other protocols for investigating and escalating and dealing with the aftermath, the remediation, responding to the complainant. Quite honestly, we've seen some of these policies that are so detailed that we are concerned that they may impede the employer's flexibility and create problems of their own. Because if you're giving yourself a list of 100 things you have to do in response to a complaint, And this is an internal document, but it is subject to discovery in the event of a lawsuit. And you fail to check every box when you actually carry out the investigation, you may be creating more problems for yourself. So it's a good idea to have internal policies on investigation and escalation protocols, but you need to look at those carefully and be sure that you're not unnecessarily tying your own hands and creating absolute rules that you need to comply with and failing to comply with that can create liability. Adrian, next slide, please. And this may be a little redundant of some of the points that Jeanine has raised, but remember, how do you defend these claims? Under the law, under the New York law, you can defend by demonstrating that the retaliation, the alleged retaliation, was in fact predicated on grounds other than the employee's exercise of their rights. So how do you do that? Well, you document job performance problems. To the extent that somebody is disciplined, you want to be able to show that there was a legitimate non-retaliatory reason for that decision. And so you document these claims. However, I will point out this mixed motive reference. Again, the New York law is new. We don't really know how the courts are going to interpret it, but under New York law, if the plaintiff can demonstrate that retaliation was just one of many reasons for the mistreatment of the employee, the alleged mistreatment, if the employee is being excluded because they're doing a terrible job, that's not illegal. But if retaliation forms even a small part of it under New York law, that may still be illegal. So we got to be very careful about retaliation not being a motive for any treatment of the employee. Next page, please. So anyway, this may be self-evident. Documentation is just key. It is important. You've got a record. You can remember the facts because you're going to forget if you don't document it. And it is also helpful to the employee because it demonstrates you understand their concerns. It shows that you've made a reasonable effort to work with them to resolve the issue, and the employee is more likely to accept the conclusions of the investigation if the problems have been documented. Can we go to the next slide, please? And if we don't document, well, of course, that's in no one's best interest because their performance may not improve. There may be a negative impact on the company. You're going to have more difficulty defending a claim of retaliation if you have not documented the employee's performance problems. And I'm going to hand it over to Jeanine to wrap it up.
So performance appraisals, you want to make sure it's the most important way to document job performance, making sure you're telling the truth, be balanced, be fair, quantify and identify the strengths and weaknesses. And we see that grade inflation is often the biggest issue. You're not being fair to the employee. They don't know what the problems are. You're not fair to you if you cannot get the best from your employee, and you're not fair to the bank if you and the employee are not satisfied. So inaccurate performance appraisals puts the bank and you at risk if there is a lawsuit. Next slide, Adrian. I often say, if I have not said documentation at least 5 times in a training, then I have not done my job. And I know people get tired of hearing it, but I still, unfortunately, get those cases that come to me where someone has blown the whistle and then the employer says, well, their work performance was terrible. And I say, okay, where are the documents showing that? And there are none. So those cases still happen. So we continue to say document, 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 because it really is key. Providing that employee feedback. It's really sharing information in a way that encourages the person receiving it to accept it, reflect on it, learn from it. As I said in the last slide, giving that performance evaluation, giving that feedback gives the person an opportunity actually to improve, to get better. And you need to use it to obviously show appreciation as well. Many of my clients always have, what people have done best up front, and then opportunities. What are their opportunities? How can they improve? Regularly asking, providing, and acting on the feedback from leaders, colleagues, and clients throughout the years really does enhance their growth. And there's no one way to ask for or to give feedback. Send an email, have the conversation, that even if you have the conversation, put it in writing, I think is always important. Next slide. And you can always, of course, email it to yourself, record details of the conversation with an employee. You can, email it and put it in the file for various issues to human resources. And emails, obviously, you can organize them if you're a supervisor yourself the way you want to, obviously being careful to preserve confidentiality. So I'm sure, your company, has a way that you should, probably handle all of your evaluations and making sure you're preserving confidentiality as well. Next slide. And just to conclude, if no one has any questions, we just want to wrap up that, the whistleblower and other anti-retaliation laws, as we've talked about throughout this entire presentation, they're really designed to encourage internal reporting of complaints or perceived unlawful conduct. As I mentioned previously, my clients who have developed strong policies internally, we often end up having an investigation and giving the results of the investigation. And often people just want to feel like they have been heard. And if you can keep those complaints internal without that person feeling the need to go out to a regulator or someone outside of the bank to get that type of resolution, then you are in a better place if you can keep those internally and handle them internally. And they won't come to you internally unless you have those good policies in place to make sure people can complain and feel comfortable complaining. The laws work in the bank's favor by giving them that first bite, the first opportunity to address these issues. And it's in the bank's best interest to promptly investigate and take required action. What if there are issues? If there are issues and someone has provided you with that information, it gives you that opportunity to act on that before the regulators themselves, even without that whistleblower or someone going outside to tell them, comes looking. And when the employee does not have that safe complaint reporting procedure, they turn, as I mentioned, to the lawyers and the regulators. So that concludes our presentation. And are there any questions? If not, then we are done.
Thank you so much, Phil and Jeanine. That was great. We always appreciate that you don't just walk through the law, but give really practical advice and share your experience. That's what makes these webinars really valuable to our members. So thank you for that. Thanks to everyone that attended. The deck is, the deck has been distributed, and we appreciate your engagement with the IIB. Everyone, have a great day. Thank you.
Thank you. Bye-bye.
Bye.